Ready? Can you explain the ruling made by the Chief Justice in the case filed from Carol Joseph?
The ruling of the learned Chief Justice has once again brought clarity to the position on the qualifications for voting and the qualifications for registration. And it is not that these positions have not been clarified before. We have had many rulings on this matter, and the Constitution is also clear on this matter. However, the PNC over the years has repeatedly attempted to obfuscate and make these issues ambiguous in their quest to, in my view, disenfranchise legitimate Guyanese from exercising their right to vote. And when I get into the ruling of the Chief Justice itself, the court made that a pronouncement that this case, if decided in the manner put forward by the applicant, would result in a disenfranchisement of Guyanese. And that is the strategy that the PNC has been pursuing for years. The Constitution of Guyana is the supreme law. The Constitution of Guyana speaks to who are qualified to be registered and who are qualified to vote. The Constitution at Article 159 says very clearly that every Guyanese who is 18 years and above shall be qualified to be registered. No other requirement. That Guyanese can be living in Timbuktu, that Guyanese can be living in London, that Guyanese can be living in New York, that Guyanese can be living at Mahaika or Linden. Once that Guyanese is 18 years and above, that Guyanese can be registered. And once that Guyanese is registered, that Guyanese is qualified to vote, unless disqualified by certain disqualifications which are irrelevant for the purpose of the case and for the purpose of this discussion. So that's a clear position. And that has been the position since 1980, when certain constitutional changes were made. Unfortunately, you had aspects of our law, including the National Registration Act and the Representation of the People Act, both pieces of legislation that are relevant to elections, that were not changed at the time the Constitution was changed in 1980. So there were elements in there that could have lent to some degree of ambiguity in construing and interpreting the constitutional requirements that I just outlined. That unfortunate ambiguity formed a platform for the PNC to repeatedly try to disenfranchise Guyanese who are qualified to be registered and who are qualified to vote. In 2019, they tried to do that by a house-to-house registration process, where they wanted to scrap the existing voters list and National Register of Registrants and create a new system, disenfranchising, therefore, all those people on that new system who may not be captured by the new registration house-to-house exercise that they wanted to commence. We went to the court and we said, court, if Mary Jane is on the old register that they're going to scrap, but Mary Jane has moved from the east coast of Demerara and is now in Region 9, or Mary Jane has moved to London and they go to Mary Jane's old address on the east coast of Demerara and they do not find Mary Jane there, they are not going to register Mary Jane. And if they don't register Mary Jane, they are going to eventually deprive her of her right to vote at an election. You follow me? It's as simple as that. And the court, and we went through the whole legal arguments with all the cases, how important the right to vote is, and if there is any ambiguity in the law, it must be resolved in favor of enfranchisement and not disenfranchisement. But in any event, the law as expounded in the Constitution is crystal clear on these matters. And therefore, the Constitution must always be construed and interpreted liberally and purposively for the purpose of advancing, enlarging, and securing rights, not depriving and restricting rights. That's the interpretative canon that must be used when construing a constitution, and a constitution like ours in particular. The court then, comprising of the same Chief Justice, she was an ordinary High Court judge at the time, she heard the case, fortunately. And in a very reasoned judgment, upheld our submissions, confirming that the right to vote is a fundamental, sacrosanct right, and that the right to vote in Guyana is not based upon any residency requirement, but is based upon citizenship and based upon age. And once registered, that right must be exercised. Any other imposition that will interfere with that right, that imposition would be unconstitutional. And that is why Claudette Singh, when she was a High Court judge, had ruled that the insistence on the use of a voter's ID card to vote was unlawful. Why? Because if you didn't have that ID card, but you were a Guyanese, you were registered, and therefore you were qualified to be registered, you were entitled to vote, but you didn't have that ID card, and therefore you lost the right to vote. And that was unlawful. That happened in the 1997 elections. So I give you all those examples so that your viewers can understand that we have traveled this road many times. And the PNC has been there all the time. They have been the one who championed the cause for the use of an ID card in 1997. And they got through. And that election was set aside because they imposed a requirement that the Constitution did not provide for. Now again, through this case, they were trying to impose another requirement. That is, they are saying that a person must be resident at an address before that person is qualified to vote. They are saying if GCOM goes to that address and that person is not resident at that address, then that person should not be registered. And if that person is not registered, then that person can't vote. So you see how, working backwards, how they are attempting to disenfranchise Guyanese who are qualified. And that is what this case is about. And the Chief Justice, again, reviewing all the cases, including a case that this same applicant, Carol Joseph, filed in 2022 when we were approaching the local government elections. The Chief Justice crystallized the same issues again in a written judgment and dismissed her case. The PNC, again persevering with her, has approached the court again in another attempt at these elections now, the intending elections, to refuse to register persons or to remove persons from the list if they are not resident at an address at which they are registered. So that, in a nutshell, is what the ruling was about, and the Chief Justice said that significantly they were inviting the court to look at an amendment which we did to the law in 2022. Now, by that amendment, significantly, all we were trying to do is to bring the Registration Act in conformity with the Constitution. Because as I said, the Registration Act had remnants of residency as a requirement to be registered. And whereas that is not a constitutional requirement. And insofar as it required residency, we removed it. And we said once you have an address, you can give that address to the registration officer. And that will be the address for you on the records at GCOM. And when you are registered and when time comes to vote, you will vote at the place closest to that address. So if you live at Kitty, you will vote at the polling station closest to the address where you are registered. What is wrong with that? They want to conform that you are living at that particular address, that you are actually resident there. So we give many examples. A person can live in the United States, but they are Guyanese and they are registered, and they want to vote in Guyana, and they want to travel home to vote. So how can you deny them that right? Because they're not at a particular address. In my arguments, for example, and hopefully when you ask me the questions, I will explain all of these things. A person can give the High Court address, the High Court address as the address. Once that election is fixed, that person is registered and the election is fixed, there is going to be a polling station closest to the High Court. And it is that polling station where you will vote. It's as simple as that. So we had to go through this whole ordeal of arguing all these principles all over again, and eventually the Chief Justice dismissed the case and confirms once again that once you're a Guyanese and you are 18 years, you are qualified to be registered. And once you are registered, you are to vote. And where you are to vote at a polling station closest to the address where you are registered. You don't have to live there. If you live at an address elsewhere, you will have to travel to that address to vote.
And that brings me to my next question, AG. It was mentioned that the applicant provided no evidence to support her contentions. Can you go into detail about this?
So that is exactly what I was explaining. The applicant told the court that when a person is registered or seeking registration and they give an address, GCOM is required to go to verify that address. According to the applicant, when they go, the house is, for example, the address is a dilapidated house. The address is an empty house lot. The address is somewhere that is not habitable. But these were only scenarios that the applicant put forward. They were not real cases. She couldn't point to, by evidence, to any of this situation being a real case. She was surmising, in other words, creating in her mind, for the purpose of the court, hypothetical examples. But in my arguments, I used those hypothetical examples, and I said to the court, let's take the examples. Let us say it is a dilapidated house. That is the address. What is wrong with that? Why a dilapidated house cannot be my address? Why? Why I cannot live in a dilapidated house? And why do I even have to live in a dilapidated house if I want to vote at that address? Where in the law says that I must live at that address? That I must be resident at that address? So I even gave the example of the Kitty bandstand. If I put that as my address, that is my address. No law says that I must reside there. I give another example. I applied for a house lot and I got it, but I have not built on it. I live in the United States of America. It is established beyond disputation that I don't have to live in Guyana, but I can vote. And if that is my address, I don't live there, I live at the Marriott Hotel when I travel, but that is my address in Guyana, that empty lot. And if that is my address, that is where I have to go and vote, the polling station nearest to that. What is so mystifying and mysterious about that? So not only did the examples that Carol Joseph gave to the court unsupported by evidence, but even if you were to take them as real examples and use them to and apply the legal principles to them, you clearly saw that whether the applicant is, whether the registrant or the voter is living at that address or not, it bears no relevance to that voter right to vote at a polling place closest to that address. So, yes, so that's how I'll answer that question.
Okay, great. And it was noted that there was some tension with the Guyana Elections Commission. Can you explain to the public what is really happening here?
Well, the Guyana Elections Commission's counsel, the legal advisor who appeared for the commission, took some very unfortunate positions that were not consistent with the position of the Guyana Elections Commission. Because he, strangely, was advancing a case for the construction of some separate list to conduct regional elections. Why? Because he is arguing that Article 73 of the Constitution speaks to voting for the regional democratic councils by persons who are residing within those regions. But a rudimentary and elementary practical understanding of the electoral system would render those arguments completely irrelevant, fanciful, academic, and useless. And such an argument should not come from GCOM, the machinery that administers the elections. Because GCOM sent a lawyer to advocate a cause that GCOM itself is not practicing, because the elections are held by one list. And from that list, you're qualified to vote, and you are stated to vote for both regional and national elections. So if you live at Land of Canaan, for example, so you are registered at an address in Land of Canaan. When you go, you will see a ballot with your name, not with your name, you will see a ballot, and the ballot will have two divisions, a top and a bottom. The top is national, you're voting for the national elections. And the bottom, you're voting for the RDC of Region 4, because that is where you live. So again, an understanding of how the system works will not permit a misunderstanding of the issues. And nobody should know how the system works better than GCOM. Except when GCOM lawyers went to the court, a different story was being told. And that's a matter that GCOM will have to deal with internally. Hopefully they will not have a lawyer at election time who will not understand how the electoral machinery functions. You see, one can have academic views and one can hold one interpretative position, whether right, wrong, or indifferent. But one can't project those personal idiosyncratic views as wrong or as right as they may be, into a public entity where national interest is concerned. You can go and do that in your own private practice if you wish. But when it comes to matters of national importance, national ethos must take precedence. So hopefully GCOM will address that issue. But the argument that he was advancing is that Article 73 of the Constitution requires you to reside in the region in which you are voting. But that very article reads that to vote at the regional elections, you have to be registered in accordance with Article 159. And 159, which is the core article, the core registration article, and qualifying article to vote, doesn't have that requirement. So you have the position where you would be qualified to register because you're 18 and you're a Guyanese. And once you qualify to register, you registered, you then qualify to vote. But when you come to Article 73 now, they are telling you that, wait now, you have to be resident in a region. Resident in a region. Or residing in a region. Before you can exercise this right. But you have an address in the region. Because as I said, your address is the land of Canaan. You may be living in Georgetown, but as your registered address. You obviously would be permitted to vote at that land of Canaan address. So residing there has to be interpreted sensibly. It can't be interpreted in a manner to defeat one's right to vote. As I said, any time you're construing a constitution in relation to the rights and freedoms of the citizens, in particular, a sacrosanct and sacred right as the right to vote, you must interpret the Constitution liberally, generously, in a manner that would enlarge, augment, enhance, further, and advance the right to vote, not to restrict or to deprive the right to vote. These are fundamental tenets of law that unless you understand them, you will never get it right in law. I don't know how else to put it. And the PNC do not demonstrably, as is evident over the years, do not understand these basic elementary principles that I'm speaking about. And that is why case after case, they are getting it wrong. You see, what you want to advance politically is quite different from what the law will permit. And they could never be able to separate those issues. They seem to always conflate their political ambitions, their political objectives, with what the law permits. And they believe, and authoritarians and dictators think like that. They believe that whatever they want to achieve, whatever political policy they wish to pursue, that the law must accommodate them. And many times the political policies that they want to pursue are things that are deprivation of rights of that type, denying people's right to vote, taking away their property, and they have a long history of that. And that is what informs their thinking. You see, your politics is informed by your ideology. Your ideology is manifested in your actions. And that's what you're seeing there. You're seeing authoritarianism. It is in the same school of thought that led them to rig elections for 28 years. The same type of thinking. They live in a democratic society, but they still can't understand that a democratic society is governed by constitution and laws, not by your political whim and fancy. They want the law and the constitution must bend and bow to their political whims and fancy. The law doesn't permit that. Right?
And before we wrap up, AG, is there anything you think the audience should know about this specific ruling?
This ruling has once again clarified, while there is no need, in my view, for further clarity, the PNC, in particular, Vincent Alexander, has been leading a charge to confuse and obfuscate the issue. It is my view that they don't want to go to an elections because they see them losing badly. So they have been trying to construct one obstacle after the other to prevent this election from taking place. And this is one of those obstacles. It is in the same vein they are arguing for biometrics. This ruling again has illustrated and has confirmed, in my view, that if we are to use biometrics without a constitutional amendments, let me rephrase that. If we are to insert a requirement for the use of biometric without amending the Constitution, then we would be adding a conditionality to vote and a qualification to vote that is not provided for by the Constitution. And the jurisprudence and the philosophical ethos and principle which flows from this case would render any requirement for biometrics as unconstitutional as the Chief Justice said this residency argument was or is. In the same vein that the Chief Justice is saying, look, residency is not a requirement to vote, the Chief Justice would be saying, and is likely to say, in an appropriate case, that biometrics is not a requirement to vote. And if you put that in the law, or if you make that an administrative requirement of GCOM, and you compare it against Article 159 of the Constitution, then you will be adding a fetter against the right to vote that is not countenanced or provided for by Article 159. Let's go back to the basic. Article 159 says you must be Guyanese, you must be 18 years and over, and then you are qualified to be registered. And once you are registered, you must vote. Where in these three things is there a requirement for biometrics? If you put biometrics in this equation here, you are adding something that the Constitution says is not required. And if you do that, you're violating the Constitution. Because you will be disqualifying somebody who fails some biometric test. And that has nothing to do with the person's right to vote. Because the Constitution didn't say that you must pass any biometric requirement before you are either registered or you are to vote. It is as clear as that. I don't know how many times we have to keep explaining these things over and over again. But we have to keep doing it. We have to keep dispelling ignorance, dispelling political machinations, and dispelling the propaganda that is intended to mislead the voting population and perhaps the international community. We have to constantly keep dispelling these attempts at obfuscating clear legal principles and clear constitutional matters.